And we have Mr. Calderon next. Thank you. This is AB 159.
Thank you, Madam Chair and members. I'd like to start today by thanking the committee for their assistance and want to accept all of the committee's amendments as detailed in the analysis. I also want to thank the California Medical Association for working with my office on additional amendments to ensure that AB 159 provides strong protections for patients and physicians. AB 159 will allow eligible patients with a terminal illness to seek investigational drugs and treatments under the supervision of a physician in order to try and save their own lives. Currently, FDA regulations do allow for expanded access to investigational treatments for those patients with serious or immediate life-threatening diseases or conditions. However, the application process can be long and cumbersome and sometimes takes up to several months to gain access to treatment. The terminally ill do not have the luxury of waiting, and not when they have weeks or possibly months to live. 12 other states have recognized the importance of right-to-try legislation by enacting comparable measures. An additional 26 states have introduced similar bills that are awaiting approval. These measures have passed with bipartisan support, which only reinforces the fact that the right to try to save your own life is not a partisan issue, but in fact a human issue. AB 159 is simple. If you, your parent, or your child is faced with a terminal illness, they have the right, or you have the right, to try and fight to save your own life. Thank you, and I respectfully request your aye vote on this important piece of legislation. With me in support, I have Donna Seitz on behalf of the LA County and Kurt Altman on behalf of the Goldwater Institute.
Thank you. And just for members, if you want to look at the amendments, they're on page 8 and 9 of the analysis. In support.
Donna Seitz, representing the Los Angeles County Board of Supervisors. I believe the Assembly member characterized the bill very well. Patients who have exhausted their options to find a cure for their disease deserve to have experimental treatment that could prolong their lives or perhaps improve the health conditions that they are living with on a day-to-day basis. And for these reasons, we would very much appreciate your aye vote. Thank you.
And another witness in support.
Thank you, Madam Chair. My name is Kurt Altman, again, from the Goldwater Institute. I am a drafter of similar model legislation to Assemblymember Calderon's that's been running around the country. I've been able to testify and provide information on these bills in about 25 states or so, and I'm really here, I'm honored to be here at the invitation of Assemblymember Calderon to answer any questions, address any potential concerns that this committee may have from the FDA process to the legality to how this bill operates, and really discuss what's happening around the nation if this committee should have it. But I would urge an aye vote on the bill, AB 159. Thank you.
Thank you. Others in support from the public? Please step to the microphone and state your name and organization.
Tricia Hunter, American Nurses Association, California, in support of the bill.
Thank you. Those in opposition?
Thank you, Madam Chair and members. Amy Durbin with the California Medical Association.
Yeah, please come and take a seat.
Thank you. I'll be brief. We've been working well with the Assemblyman on the bill. Appreciate the good intentions behind it. We are technically, as reflected in the analysis, still in opposition, but we think the most recent amendments taken in the last committee were a great step forward in addressing our patient safety concerns. Have suggested a few additional amendments to the author, and we're continuing to work those out, but confident we can have our remaining concerns addressed.
Thank you.
Madam Chair, Member Stephanie Roberson, on behalf of the California Nurses Association, still regretfully in opposition. Had an earlier conversation with the Assembly member about the issue. While we believe that the goal is laudable, we still want to make sure that there is an actual remedy for patients in the state of California to actually receive these life-saving medications. But we believe that nothing in this bill or any other bill that has been passed on the subject impacts the availability of drugs for terminally ill patients unless the manufacturer of drugs allow it to be used in advance of FDA approval. And there's so many reasons why manufacturers don't make their drugs available for compassionate use. It could be regulatory, administrative. But when we looked at some of the studies, 86 of the over 32,000 studies enrolling new participants were unavailable for expanded use. Not making an excuse for manufacturers, but there must be industry participation. Also, manufacturers are not exempted from FDA rules just because states enact legislation asserting that it gives the citizens the rights to do so. Again, we want to, champion and work with these patients, these terminally ill patients. Our nurses, our constituency, of course, see patients through the beginning of their life to the end. So we are definitely, supportive of the goal, but we want something real to happen. We've looked at some of the cases. I think the New England Journal of Medicine had put out a report on this. They thought that the appropriate use of states involved in this issue, they could look at setting up multi-institutional review boards to take a look at the issue to fast-track the issue. We also know that on February 4th, the FDA released new guidance on the expanded use and streamlining its efforts. So that's still in play. I haven't heard, the latest on that, but we know that's still in place. So at the very least, this bill is premature. We should see what the FDA is doing on that issue and then come back to this. But, it's expanded use and the cost of drugs is a issue that continues to plague this state and this nation. And we just want to kind of take a step back, look at what the FDA is doing, really look at the bill to see if this is providing real solutions for terminally ill patients, and then just see how the FDA process is playing out because we feel the bill is premature. To that, we still oppose. There's also an issue that the medical board and the osteopath board cannot take action against a doctor on the whole misconduct issue. We know, especially in this committee, that there's checks and balances that should be appropriately applied. Those are those checks and balances. We should take a look at that and make sure that is also in this bill. We hear that there's conversations with the Med Board on that as well. It's a concern to us. So with that, I appreciate the time, and we still oppose the bill.
Mm-hmm. Thank you. Questions from the committee? Yes, Mr. Mullen.
Thank you, Madam Chair. Mr. Calderon, thank you very much for bringing the bill. My district is the epicenter of life sciences, biotech, pharmaceutical industry. I know that pharma was listed in opposition, but I believe you've been having some fruitful conversations.
I forgot to see if there's other opposition.
I'm sorry.
From the audience. I didn't ask for other. Did I? Is there anyone else opposed? Okay, we got them all. I'm sorry. I just wanted to make sure.
Just wanted to ask you about those conversations with pharma and where the nature of their concern lies at the moment.
We have no opposition from pharma. They have submitted a letter of concern, but pharma has not gone in opposition to this bill. They are neutral, specifically on this measure in terms of the drug manufacturers.
Okay, thank you. Other questions? Mr. Wood.
Yeah, and it's just a procedural question. I assume that if this bill were to be passed by the legislature, ultimately signed by the governor, there will be an extensive regulatory, or maybe I'm wrong. Is there some sort of a regulatory overview, oversight about how this is ultimately put together?
Well,
Does somebody have an answer for that?
Go ahead.
Madam Chair, Assembly Member Wood, that would certainly be up to the state regulatory board and the state of California. Each state that has passed this law is implementing different procedures based on their local practices and best practices. So certainly this bill in its own, AB 159, doesn't call for the regulatory procedures, but it certainly leaves that option open, and frankly is probably an expectation that regulatory rulemaking would take place to kind of govern the application of this law.
Nothing in the bill spells that out.
I guess my question is, would the author have any objection to that?
You know, the point of the bill is to provide the option. You know, what we're trying to do is give people the choice to try and save their own life in a time where we don't really believe that option is available to them. This bill, when you take a look at what other pieces of legislation have passed in other states specific to this issue, is far beyond what it goes far beyond in terms of regulation, goes far beyond in terms of protections than any other bill goes. And, you know, we're adding in, specific to these amendments, an independent review board. So we are providing a guideline, but we're expecting that, I mean, I'm more than happy to have this conversation as we continue to move forward, but what we don't want to do is we don't want to handicap ourselves, we don't want to handcuff ourselves to a point where, you know, in this discussion, I think it's easy to put ourselves in a position where we kind of end up with a bill that doesn't really do anything other than just allow the current standards to move forward. And so, I mean, we're open to discussions. However, the point of the bill is to allow that choice, and we don't want to put anything in the bill that takes away the ability for somebody specific in this state to have a physician that they can go to get these drugs in a timely manner to try and save their own lives, specifically when they only have a few months or a few weeks to live.
And through the chair.
Yes.
And while I completely agree with that, I guess I'm always concerned about the unintended consequences, and so I would look forward to working with you on that. I think first and foremost, I mean, one of our jobs is protection of the public, and I believe part of it is protection from the public from unintended consequences. So I understand, appreciate where you're going. I like the fact that you have been able to work with some of the opponents and make significant progress. And you know, I voted for this in Health Committee, so I clearly get where you're going. Now I'm in a different hat, in a different place, and it is about protection of the public. So that is a conversation that I'd look forward to the opportunity to continue some of that, and I do appreciate where you're coming from. I really, really do, and you know, I will be supporting this, but with that caveat that I just want to be sure that we have that regulatory or some sort of check and balance.
Just to perhaps provide partial answer to your question, we've added in as one of the amendments the process of an IRB, the Institutional Review Board, but that's the only, it's not a regulatory board, but it is a review board, and maybe we can come back and explain briefly the role and the constitution of an IRB. But Mr. Bloom, you have a question.
Thank you, Madam Chair. I agree that this bill has very good intent, and I intend to support it today. But I'm concerned, and perhaps the gentleman from the Goldwater Institute who's been involved in other efforts can help fill in the blanks here. Are there people at this point who have been able to avail themselves of drugs under these circumstances that the bill is intended to assist in?
Yes, please answer.
Madam Chair, Assemblymember Bloom, to date, I can tell you that there hasn't been, and I'll explain that. And I can also tell you that there are a number of states and a number of physicians that are preparing to implement right to try laws. Last legislative session, we'll call it 2014, 5 states passed this law or similar laws, and they went into effect in late summer, early fall. So they're very new laws. Certainly this is a new avenue. It's actually pioneering and revolutionary, let's say. And those states are preparing and putting together procedures and getting ready to use the law. But to date, I cannot tell you a patient that has done that. This year, and actually the numbers have even gone up since Assemblymember Calderon indicated, there have been 9 states that have passed it this year, so we're at a total of 14. None of those states' laws, well, I take that back. Only Indiana's state law went into effect with an emergency clause. Every other one has a 60 or 90-day waiting period, so we expect the laws to actually be effective at the end of the summer.
So essentially the answer to the question is that these are all brand new. And the real issue here is the FDA and the amount of time it takes for the FDA to approve a drug for use. And so what is going on is states are taking matter into their own hands and saying, well, if you're, as the FDA, not going to speed up the process, allow our patients access to these drugs, then on a state level we're going to do we're going to do it on our own.
Well, I understand the FDA takes longer than some other countries takes to approve drugs for new uses. However, it takes a long period of time in other countries to go through the approval process too. So I'm not sure that the rationale disappears just if simply because the FDA were to become a little more quick in their approval process. I'm really concerned that PhRMA's not here to explain its position, because I think that would fill in a lot of of what I see as gray area in this bill. And frankly, I'm concerned that the passage of the bill here and in other places is going to lead to a lot of false hope to people who are in fairly, very sensitive and perhaps desperate, is a way to describe it, circumstances. And I think that would be most unfortunate. I'm going to vote for the bill today and move it forward, reserving judgment for when it comes onto the floor. And I do hope that PhRMA will take an active role in explaining their position. I look forward to the conversation.
Maybe, thank you. Maybe now we could go back and talk a little bit about the Institutional Review Board for the benefit of the members, in terms of who sits on such a board and what role they would potentially be playing in what seems to be kind of a new frontier.
Thank you, Madam Chair. Certainly, I'll summarize, and I guess the Cliff Note version of what an institutional review board is it's a group of doctors and scientists and researchers that sit in a location, a locale, maybe a university setting, a research university setting, maybe a bigger community. But what I like to refer to the IRB as sort of the ethics police. Yeah. They are a group of people that get together when drugs like this are going to be administered outside the clinical trial process, which does currently happen now in the FDA Expanded Access Program. It just takes a long time to happen. But what the IRB does is they are the final reviewer to make sure that the application and the administration of these drugs are ethical in the situation that's presented before them, the patient's situation, the patient's condition, the drugs that have been tried, and really the IRB does the cost-benefit analysis on the ethics of that particular situation.
Okay, so for clarification, we're not considering in this bill a process where some doctor in a back room is writing prescriptions for just all kinds of, crazy things that might or might not work. Because I think that's the concern of the committee, is we don't want people in desperate situations to basically be preyed upon or misled. So the IRB, please go back to what you were just saying, currently functions around the FDA's expanded access. And is this bill, explain the interaction that this bill would have with what is currently in place and the role the IRB plays to make sure there are ethical standards in place?
Certainly, Madam Chair. Thank you, members of the committee. What the current expanded access, where people get investigational drugs, just like we're talking about here in Assemblymember Calderon's bill, through the FDA, through an application to the FDA. It operates where a doctor has to apply to the FDA, provide paperwork that still currently, even though they have proposed a change, anticipates about 100 hours of physician time. Even the FDA admits that it takes about 100 hours of physician time. They have proposed a rule to change that. They've proposed a rule. It has not gone into effect yet, but that's a good start. That paperwork goes to the FDA. The manufacturer also provides a significant amount of information to the FDA. The FDA at that time has 30 days under expanded access to approve or deny the request. And frankly, when they get completed applications, generally at about 95% of the time, they approve those. But they get very few because of the time it takes and the effort it takes to fill out the application. If the FDA has any significant issues, they go back to the respective party's doctor and manufacturer to ask those questions. When that information comes back, their 30-day clock starts again. Once the FDA approves an expanded access request, then that goes back to your local, the request then, the information goes back to the local review board that may sit at UCLA in California or some other research university. And then the IRB reviews everything that the FDA did as well and makes the ethical determination that in this medical situation, it is appropriate to provide these investigational new medications.
And so this bill is different in what way from the process you described, which is currently in place?
This bill would allow that doctor, patient, and on the doctor's advice to go directly to the manufacturer, request the investigational new drug to be applied or to be administered. If the manufacturer agrees, that drug will come straight to the doctor or the physician to be administered. But in this bill, in Assemblymember Calderon's bill, before that step, it still has the Institutional Review Board to review the drug, the situation that the patient's in, the doctor's recommendation, and make a decision on whether it's an ethical administration of that drug or not.
And that is an amendment he is taking. It was not in the Health Committee version, but it's this committee is asking for this amendment that has the IRB's involvement. So I just want to highlight that because I think it's a very important amendment. I did not vote on the bill in Health because I knew it was coming here to Business and Professions, and felt that it was not only important to have the IRB, but we also added, if you're looking at page 8, that there needed to be a biannual report to the Department of Public Health, the Medical Board of California, and the Osteopathic Medical Board with the following information: number of requests made, the status of requests, the duration of treatment, and the costs of the treatment paid by patients. So we are, through these amendments, really trying to make sure that we are closely tracking what is happening around the use of these, perhaps the slightly accelerated use of these experimental, or however we describe these drugs.
And with regard to that specific amendment regards to IRBs, that was something that I had talked to the Health Committee about and gave them my word that I would work on specifically in this committee. And Ms. Booney, I thank you and your staff for helping us figure that out.
The other important amendment is that we also are requiring a second opinion on the diagnosis, because this is only made available to patients who have received a diagnosis of a terminal illness. And we said that we wanted to have a second consulting physician confirm that as well. So felt that that was an added protection for consumers that would make sure that it wasn't something that was becoming a sideline cottage industry of some kind, that there had to be a second consulting physician. Other questions from members of the committee? All right. Would you like to close?
Yeah. I want to thank you all for your time. I want to thank you all for your questions. The real intent of this bill is, I came about this legislation not because somebody brought it to me, but because I knew Right to Die was going to be coming to the state legislature, and so I started researching it and happened upon Right to Try. And I thought that that was an issue that I wanted to champion, because in a situation, if it were me, if it were my family, if it were a loved one, I would want to know that I lived in a state that gave me the opportunity to try and fight for my own life. With regards to the drugs and the FDA's compassionate use program, the same drugs that you would get through the compassionate use program that you would be approved for are the same drugs that you would have access to under this program right now. The only difference is the amount of time. And time when you have a life-threatening illness is a big deal. This bill is all about choices. It's about having that choice to be able to pursue that in this state without having to leave this state if you can't be approved, because there is no guarantee that you would be approved for the FDA compassionate use program. And although they are looking into a streamlined version of compassionate use to try and expedite that process, it's only being talked about and it hasn't been yet approved, and they are still in the public comment period, and then they're going to vote on it. But that still isn't a guarantee. This is about giving people options to save their own lives. And I think that that point has been understood by this committee. I really want to thank the chair and the committee staff for their hard work on helping us craft what I think are absolutely amazing amendments to help us really allow that access that we want and that we need, while at the same time having protection so that the patients know that there is oversight specific to the IRBs and a consulting physician confirming beyond the primary physician that there is a terminal illness. So again, I thank you all for your time and questions, and respectfully request your aye vote.
Thank you very much. Do we have a motion? We have a motion and a second. It's do pass as amended to appropriations.
Bonilla.
Aye.
Bonilla, aye. Jones.
Aye.
Jones, aye. Baker.
Aye.
Baker, aye. Bloom. Bloom, aye. Campos. Campos, aye. Chang. Chang, aye. Dodd. Dodd, aye. Eggman. Gatto. Holden. Holden, aye. Mullen. Mullen, aye. Ting. Ting, aye. Wilk.
Aye.
Wilk, aye. Wood. Wood, aye.
12-0, the measure's out.
Thank you, members.
Thank you. And our final bill of the morning is Mr. Ting, AB 1073. Do we have another one? Oh, Jones, we have two. All right, we'll start with you, Mr. Ting. Vice Chair will wait patiently, happily.